Good morning. My name is Dan Caprio. I'm with the Providence Group here in D.C. And this morning, I have the very distinct pleasure to introduce my good friend, Commissioner Christine Wilson. We're going to engage in a little fireside chat. So Commissioner Wilson joined the Federal Trade Commission last September. Prior to her previous experience at the FTC included a spin as Chief of Staff to Chairman Tim Muris. Commissioner Wilson was also in private practice where she counseled clients. And most importantly, she was in industry at Delta. So Commissioner Wilson has all of the requisite experience in government, in industry, and in private practice. So I thought this morning, our timing is fortuitous with the.
I arranged it just for you, Dan.
Thank you very much. So you can tell we're going to be informal, which is good for IGF USA. But spend a little time talking about Facebook, and then talking about the topics that we're going to cover in the panel right after this chat on privacy, and then spend a couple of minutes on competition policy. So, Commissioner Wilson, we've known each other for a long time, and I think with the FTC, the settlement yesterday with Facebook, we're definitely having a moment. And as the FTC announced yesterday, Facebook will pay a record-breaking $5 billion penalty, submit to new regulations, and a modified corporate structure that will hold the company accountable for its decisions to make about its users' privacy. And this is all in respect to the violation of a 2012 FTC order. The $5 billion penalty against Facebook is obviously the largest ever imposed on any company violating consumers' privacy. So if you would, spend a few minutes talking about, or telling us sort of what the FTC's alleging in terms of order violations, and then the Section 5 counts in the settlement.
Sure, absolutely. Good morning, everyone, and let me begin with the standard disclaimer, however informal we're going to be. I am speaking for myself, not for any other commissioners, or certainly for the Federal Trade Commission. So as Dan alluded, it was just another sleepy summer day in DC yesterday. So we did announce yesterday our enforcement action against Facebook. We alleged a number of violations of both the order and Section 5 of the FTC Act. At bottom, essentially, Facebook misrepresented to users how their information was going to be used, and whether and to what extent they had control over how the information would be shared. So for example, they collected phone numbers and told users those phone numbers would be used only for security purposes, but then used the phone numbers for targeted advertising. They told users facial recognition would be a feature that users could opt in to using, but in fact had it turned on by default. They told users that users could specify the audiences with whom their information would be shared. So for example, if I shared information with friends, I circumscribed the audience that could see that information, but in fact, Facebook allowed third-party app developers to access all of that information, regardless of settings, and that's frankly what brought us Cambridge Analytica. And so it was a variety of violations, but at bottom came down to misrepresentations by Facebook about whether and to what extent users could control information.
Thanks. Can you talk a little bit about the injunctive relief, or the order, or how this is all going to work for Facebook?
Sure. So the idea behind the order is to create a culture of compliance. Facebook's CEO is known for saying that he likes to move fast and break things, but a culture of compliance begins at the top. And so how do you put speed bumps in front of Mr. Zuckerberg and Facebook as they deal with consumer privacy issues? And we sought to do that through a robust system of checks and balances. And it begins at the bottom in terms of the business units as they're thinking about modifying existing products or creating new products. They need to take the impact on privacy into account. So privacy risks need to be assessed and they need to be addressed, and safeguards either need to be adopted or, if not adopted, recorded and documented why those choices were made. All of that information is then funneled up to designated compliance officials and to Mr. Zuckerberg, and they need to review the information, be familiar with it, determine whether calls are being made that they're comfortable with. That information also flows to an independent third-party assessor and on up to a new privacy committee that will be created on the board of directors at Facebook. They will now have a nominating committee comprised of independent directors who will nominate the privacy committee directors. This is a governance best practice that to date Facebook had not employed. And so all of the checks and balances, both within the company and then outside the company through the independent assessor and the Federal Trade Commission oversight, hopefully create the kind of checks and balances necessary to ensure that appropriate attention is being paid to consumer privacy.
And that's really unprecedented in an order, or in certainly in the FTC, but in terms of corporate governance. Can you talk a little bit more about the corporate governance aspect, how all this is going to work? Because there's lots of board committees, and there's obviously lots of compliance and lots of attempts to have privacy impact assessments or hold Facebook accountable. But it seems to me that you've got two issues. One is an issue of compliance and operational control. The real issue that I think the FTC is trying to get at here is how do you get to identifying and managing strategic risk. So it seems as though the governance that you've been able to put in place as relief, that it'd be helpful to talk a little bit more about how you see that working.
Sure. So in terms of, again, the culture of compliance, the idea is to essentially extinguish Mr. Zuckerberg's ability unilaterally to make decisions about consumer privacy at Facebook. And so we thought long and hard about how to do that. And there had been shareholder calls in any event for Facebook to create a little bit of independence on the Facebook board of directors, such that Mr. Zuckerberg would not be completely the driving force. Obviously, he's a majority shareholder. And so we created, again, a nominating committee that's comprised of independent directors. No Facebook management or executives will be on that committee. They are the ones who nominate the members for the privacy committee. And the privacy committee is going to be, it's going to be in the charter for Facebook, and it's going to say that you need a supermajority of voting shares to remove any of the members of the privacy committee. So in other words, Mr. Zuckerberg alone cannot say, I'm unhappy with the work of the privacy committee or any member of the privacy committee, and unilaterally remove those members. It will take shareholders other than those who are sitting on the board. In other words, Mr. Zuckerberg and everyone on the board together do not constitute a supermajority. And so the idea is to take the fiduciary obligations that directors have and to ensure that with that authority, they are looking carefully at the decisions that are made with respect to privacy in this company. And I would say, I don't think this is something that every company needs to do. In fact, Commissioner Phillips and I dissented from proposed revisions to the safeguards rule that purported to dictate with great specificity how corporate governance should deal with the issue of privacy, because every company is in a different situation. And this is not a measure that we think every company needs to adopt. And we don't think that the Federal Trade Commission should be in the business of dictating these kinds of corporate governance structures for every company. But in this instance, given the violations that we found, given the scope and magnitude of the issues, and given what I perceive to be in particular a complete lack of a culture of compliance at the company, this was a necessary step.
But it does send an important message to the rest of industry, I think, that you need to value data as a strategic asset. Let me turn just to an issue of some of the some of the commentary about the settlement. Obviously, the vote for the settlement was 3-2. So there have been some prominent members of Congress that have had some pretty sharp things to say. Senator Markey said yesterday, with its settlement with Facebook, the FTC not only fell short, it fell flat on its face. And then he went on to say the settlement is a partisan abdication, which is strong stuff for an independent agency. So how do you respond to the critics and those who would say that a $5 billion fine is really just a parking ticket?
So a bit of context. We did levy a $5 billion fine. As you mentioned, $5 billion is the largest privacy fine that's been levied, not just in the United States, but globally. It is the second largest civil penalty ever imposed by the United States government. The only larger civil penalty was $5.5 billion for Deepwater Horizon, in which the Gulf was contaminated, industries were destroyed, livelihoods were ruined, millions of animals were killed, 11 Americans were killed. And so this is a significant fine any way you want to slice it. It's 9% of their revenues in 2018, and it's 22% of their profits, not chump change. Median income in the United States is $60,000. 9% of that is $5,500. If I get a $5,500 parking ticket, I'm taking rideshare everywhere. So it's not a slap on the wrist and it's not a parking ticket. And then to those who would say we didn't go far enough, obviously I believe that my colleagues in the dissent on this matter want what I want, which is to give consumers control about how their information is collected, to provide some transparency and accountability with respect to consumer privacy. I think we disagree about how to get there. There was a lot of discussion about whether to litigate or to pursue a settlement, and I think, frankly, that's some of the discontent that we're hearing from Congress. And what I would say is, when faced with the choice of whether to litigate, certainly there is transparency and accountability that comes when a company's internal documents are disclosed in open court, or when a CEO sits on the stand and testifies, as we saw Bill Gates do in the Microsoft trial. But that is a lengthy process. We would be in discovery for years. Facebook would be well lawyered. And by choosing to settle, and to get the incredibly strong injunctive relief that we did, we are bringing immediate protections for Facebook users today. We are setting out, in a sense, a set of best practices, not necessarily that other companies looking at this need to follow every single step that Facebook needs to follow. They are unique. But we are saying the Federal Trade Commission is going to use the limits of its authority to demonstrate that consumer privacy matters, and the promises that you make, you need to honor. Now, obviously, there are limits to what we can do. We're applying Section 5 of the FTC Act, and essentially deception is the authority here. So if a company makes a statement and then fails to abide by the statement or the promise, that's when we can step in. So we have called on Congress on a bipartisan basis to enact federal privacy and data security legislation that will set expectations for companies about how information can be collected and how it can be used and sold and shared and aggregated and monetized. We are happy to step in with narrow targeted APA rulemaking.
Right.
But if people want us to go further, it is Congress who needs to step in and create federal privacy legislation.
Thanks. Well, and Commissioner, that's that's a good segue into our panel topic, which we're going to be discussing here in just a minute. But in terms of which national privacy strategy should the U.S. adopt, and I know in the press conference yesterday, and you just articulated some of the things, but the need or the desire for comprehensive privacy legislation. So, and you just mentioned some of what, excuse me, some of what that would look like. But how do you see this playing out? I mean, this almost feels like this has become such a big issue that perhaps this is, an inflection point where those who would, the FTC is a law enforcement agency, not a regulator, but those who would like to see the FTC do more in a Facebook kind of environment really will get the message that we need a comprehensive privacy bill.
No, I completely agree, and that was my message yesterday to all of the folks who expressed discontentment with the action that we took, that we have gone as far as we can given the tools that we have, and we will continue to use our resources and our tools effectively, but there is a limit to what we can do, and if you want us to go further, you need to create a law to do that. And I don't want to tell Congress what that law should look like. It is up to them to balance societal values and to create sort of the bright line rules on information collection, use, sharing, aggregation, monetization, and the FTC is available to provide narrow targeted rulemaking. In other words, if they say notice is necessary, the Federal Trade Commission's DCBE, the Division of Consumer and Business Education, is fantastic at figuring out how to communicate with consumers in ways that are really accessible. We can help design privacy notices. There are ways that we can help, but Congress needs to sketch out in broad strokes the values and the limits on information sharing.
Right, so one comprehensive law, initial finding authority, APA rulemaking, anything else?
Repeal of the common
Repeal of
carrier
common
exemption
carrier.
and the nonprofit exemption in Section 5, because we want to be sure that it's a level playing field. We want to be sure that everyone is operating under the same law.
And the other criticism, of course, is that there's been some discussion of setting up a new regulatory structure. Why do you believe that the FTC should continue to be the enforcement agency? Having the history the FTC's had with privacy, but how do you respond to those who say, we need a brand new agency?
Yeah, but when I wake up in the morning, I think I need a life with more red tape and more bureaucracy and more federal agencies. But seriously, so I had the honor, as you mentioned, and you were there with Commissioner Swindle, and those were exciting times in the early 2000s when we started thinking about what a strong, robust privacy and data security program would look like at the Federal Trade Commission. We brought the Eli Lilly case, we brought the Microsoft case, we created the Do Not Call registry, and those were seminal actions. And since then, the Federal Trade Commission has built an amazing amount of expertise and knowledge in terms of privacy and data security issues. We have staff who have been thinking about these issues, holding roundtables and workshops, conducting hearings. We have brought hundreds of cases, both under our general Section 5 authority and then under COPPA, Graham-Leach-Bliley, telemarketing sales rule. We are incredibly familiar with the nuances of the issues in the privacy arena, and we are well equipped to carry out any additional authority that Congress chooses to give us.
Thanks. Let's turn real quickly, just a minute or two, the competition issue. So later in the day, we're having two different competition panels. Antitrust doesn't work for tech, and is the techlash justified? Where former acting chairwoman Olhausen is speaking. So, thinking about competition and all the discussion around town, talk for a minute about what the FTC has been doing, and the role of the FTC Tech Task Force.
So, coming into this season with 5 new commissioners, Chairman Simons rightly surveyed the landscape and saw that there is a lot of discontent about various issues within the tech space and within the economy more generally. He launched a series of hearings, the competition and consumer protection hearings in the 21st century, modeled on what Chairman Petofsky had done in '95. And the idea is to listen to hundreds of different stakeholders. We've had hundreds of witnesses and hundreds of comments and input from, a vast array of perspectives to think about how we deal with issues today. And as you mentioned, Chairman Simons recently announced the creation of the Tech Task Force, which is going to look at consummated deals, prospective mergers, conduct in this space, and it will be a very thorough review of competition in the tech space. And this initiative is modeled on what we did with hospital mergers in the early 2000s when you were there and when I was there. And when you take a lot of really skilled, smart, experienced people and you focus them on certain discrete key issues, you get really great thinking and really great results.
Right. But one of the things that and I agree and see the way that was that Chairman Simons modeled that. But one of the things that seems very different now as opposed to then is the consensus that we've had for 40 years on the consumer welfare standard. That consensus seems to be fraying, I guess, which is a charitable way to say it. But what do you? I mean, and you've spoken about this. You talked in your separate statement in Staples about hipster antitrust, and what do you see as I mean, do we need to modify the consumer welfare defense, or where do you see? I mean, this is a big question, but where do you see all this going? Because we're having this large national conversation about consumer welfare that we really haven't had for a few decades.
So a couple of points for those who don't practice antitrust law on a daily basis. A welfare standard is the standard you use to determine whether conduct is lawful. And in the consumer welfare standard, you look at the impact of a merger or a business practice on consumers. Will they be better off or worse off? Will they experience higher prices and lower levels of service and less innovation? Or will they get the benefits of robust competition, lower prices, higher quality, more innovation, more choice? And those who criticize the consumer welfare standard, I think, are doing so not necessarily because they take issue with the standard. I think there is a concern about greater concentration, more monopolization in the United States. If you take a close look at the statistics and the data that they're using, you will see that there's a lot of gerrymandering, and there are a lot of issues with the data. But they are attacking the consumer welfare standard as a way of essentially lowering the bar for the kinds of mergers that get challenged and the kinds of conduct that get challenged. And they are incorrectly characterizing the application of the consumer welfare standard by saying it only takes into account price. And that's just not accurate. We have dozens and hundreds of cases that show the consumer welfare standard takes into account a lot of non-price factors. What's the quality like? What is choice going to be like? How will innovation be affected? And, frankly, I think the consumer welfare standard has done a really great job of guiding us in terms of enforcement, and I would hope that the consumer welfare standard weathers this latest attack.
Commissioner Wilson, thank you very much. We've covered a lot of ground. I wish we had more time, but thank you very much for your comments and for being with us today.
It's my pleasure. Thanks, Dan.